Good morning and a very warm welcome here from our offices in Johannesburg. This is the Free Market Foundation, and I'm happy to welcome both the members of the public as well as the members of the media to our media briefing today. My name is Morne Malan. I'm the Deputy Head of Policy at the Free Market Foundation, and I have the honor of hosting today's media briefing, which is the fourth in our wide-ranging series of policy proposals to the now not so new Government of National Unity. Previously, we discussed topics regarding freedom to trade internationally, reducing the size of government, as well as removing the regulatory burden on the South African economy. Now, of course, all these other briefings are available on our YouTube channel. Do feel free to look at those if you're interested, or if you want to read the entire policy paper, you can go to our website. That's at libertyfirst.co.za. And while you're there, feel free to share our content, to like our content. All of that really helps us in spreading the word, in creating more impact and becoming more effective in advancing liberty. Now, the paper we are about to discuss today, or the latest paper in the series, is titled Liberty First, Legal System and Property Rights. And what the topic we're going to delve into more broadly is, amongst other things, the notion of the rule of law. And I think there might be some misconceptions regarding the rule of law in South Africa and globally. Rule of law isn't just a concept that says, when there are laws, they have to be mercilessly and stringently enforced. That's, of course, part of it. But another part of it is to make sure that the laws, such as they are, reflect to the greatest extent possible also the values and the interests and the preferences of the society that the laws purport to represent. And in this paper, Martin van Staden, who is the head of policy at the Free Market Foundation, really looks into that concept of the rule of law and looks at the extent to which not only our laws reflect the values of the society, but also the extent to which those laws can be enforced. There's this old metaphor developed, I think, by Bruce Leone and also taken further by Friedrich Hayek, which is this metaphor. It's an analogy of a university campus. We have all these different buildings where different people in the community, students and lecturers, they want to get to those buildings. That's basically the constitution of a country. That's where everybody wants to go, the goals that we are hoping to achieve. What legislation hopes to do, and maybe it's worthwhile to distinguish between law and legislation, but what legislation hopes to do is to lay the paths to get towards those goals, to get towards those buildings on the university campus. And there's basically two ways of doing that: either having people, getting experts in, having them develop the roads, having them lay out those roads, and telling everybody else to follow those roads. The problem with that is, if that doesn't really reflect the way that the community wants to reach those goals, then people just simply aren't going to follow those paths. People are going to create their own paths. Another way of developing legislation is to say, let's wait a while, let's see where people are moving, let's look at where the ditches start to form in the ground, and then simply lay the paths there. And that's what rule of law, at least in one sense, in one narrow sense, also represents. It's to look at what the communities can do, look at what they want to do, and to base policy on the desires and the preferences of the community, of the society, as opposed to attempting to, from the top down, enforce policies which oftentimes the state doesn't have the capacity to enforce, and other times, due to the fact that there's simply no buy-in from the community, they cannot enforce. Now, enough from me. I've already alluded to him, but I'm going to mention the author of today's paper, and that paper, just again, is Legal System and Property Rights. Again, that's available on our website, libertyfirst.co.za. And the author of today's paper is one of the hardest working people advancing the cause for liberty on the entire continent, and that is Martin van Staden, the head of policy at the Free Market Foundation. Martin, please feel free to continue.
Thank you very much for that flattering introduction, Mornay. Much appreciated. And yeah, thanks again to everyone for joining us this morning. I think we've gone into a lot of detail over these past few weeks about why economic freedom is so beneficial. Not simply to abstract ideas like economic growth, everyone talks about that, or dynamism, but really to tangible economic experience that the poorest of the poor in our society live every single day. So according to the Fraser Institute's Economic Freedom of the World annual report, which we call the EFW, the poorest 10% of the population in countries with the freest markets in the world earn about 250,000 Rand on average per year, compared to the only 30,500 Rand earned per year by the poorest 10% of the population in those countries with the most interventionist governments. So allow me to be very explicit about what I'm saying, ladies and gentlemen, and that is that free market capitalism is good for everyone, but for the poor in particular. The Industrial Revolution, which heralded capitalism as we really know it today, was a turning point in the lot of the ordinary masses. It began the process of ending absolute poverty, which is something that those countries that truly embraced capitalism achieved within the last 100 years. The end of poverty is a new phenomenon in human experience, and it's a shame that we haven't reaped the benefits of that as much as we could in South Africa, but around the world, where people really were just as poor as people are today in Africa, this problem has been solved to a very large degree. But virtually without exception, those countries with large and sometimes growing numbers of absolutely, not relatively, poor people, they remain those countries that are either ideologically or by tradition dedicated to having large governments that routinely intrude into the economic freedom of ordinary people and of commercial firms. But capitalism, despite its wonder, does not materialize out of thin air. It stands on foundations, and in this context, I'm referring specifically to the twin pillars of constitutionalism and private property. When you do not have a legal system, in particular independent courts and a strong criminal justice dispensation, which ensures that agreements are kept and that violence is minimized, you cannot have prosperity. And if you do not have private property rights, the incentive structure of your economy becomes fully entangled in the wants and desires of the political, more specifically the state elite, which usually means poverty and deprivation for everyone except those who are close to the ruling party. And we saw this at a grand scale in the former communist bloc, and we still see it specifically amongst countries that, while they might not be explicitly dedicated to socialism anymore, a lot of those premises still linger within how their governments approach what is often called managing the economy, a very perverse idea that our press also has latched onto. But don't ask me. Daron Acemoglu and Simon Johnson, who received this year, 2024's Nobel Prize in Economics, have also argued, as have legions of economists and jurists before them, that property rights and legal institutions are linked very intimately with economic flourishing. And I think at some level, all of us understand this intuitively. And this is why 2024 is such an important year potentially. This year, the party that has ruled South Africa absolutely for 3 decades lost its parliamentary majority, leaving us with a coalition government. And this so-called government of national unity that Mornay already alluded to now contains multiple parties that have for many years championed stronger legal institutions, rule of law, and property rights. So what we have is, again, potentially, but not necessarily, a government that could bring about much needed reform in the areas of property rights and legal institutions. And if that happens in substance, ladies and gentlemen, that will help South Africa do much better when it comes to safeguarding the highway to prosperity for all. Now, out of all South Africa's EFW rankings, we already rank best on legal system and property rights compared to our other rankings. And relative to most of Africa, we fare pretty well. But there are a few things that I think should be noted about the rank and the score. So where we do pretty well is our relative rank, not our absolute score. And that's where we look so good. The ranking tells us how we compare to other countries, and the score tells us whether we're doing well per se. So our rank is 59th out of 165 countries, which is good because in the case of the rank, the lower, the better. So, and we're quite low compared to, we're certainly in the second quartile, I would say. But our score, on the other hand, is only 5.78, and that is not good because the higher the better. So we're already in the worst half of the score when it comes to how well we do absolutely in terms of legal system and property rights. The second thing to note is that in this area of the EFW, unlike the other areas, sound money, freedom to trade, regulation, and size of government, in this area, legal system and property rights, the research is based on survey results rather than original policy research. So to a large degree, our score and our rank on legal system and property rights is based on how people feel South Africa is doing, rather than actually wrestling with the policy facts that exist on the ground. And I don't want to create the impression that these feelings are irrelevant. How people feel about where they live and what they perceive is crucial. It is certainly not useless or irrelevant. But it is something to bear in mind, especially because I think that if you ask ordinary South Africans their thoughts about the strength and integrity of our legal system, which of course includes our criminal justice dispensation, and property rights, which includes security of tenure for everyone, you might get a very different picture. So that is something that has to be borne in mind. So this is to say that even though South Africa does not do terribly in this area of research, we certainly do a lot worse in our other EFW areas covered in our previous briefings. We can still, even in this relatively better area, we can still and we must do better. And in this respect, the Free Market Foundation has made various proposals, and we've divided these into 4 categories on the topic of legal system and property rights. And they are federalization, rule of law, private property, and civil liberty. Now, astute observers will immediately notice that each of these categories of reform are already characteristics of the South African Constitution, meaning that nothing we have proposed is inconsistent with the constitutional design, or that it even necessitates change to our Constitution. And I will now briefly run through these discrete proposals, but because of limited time, I am barely scratching the surface, really, and I do encourage you to read the full paper, which, as Mornay said, is available on our website. So firstly, ladies and gentlemen, federalization. Constitutional scholars will know that South Africa is formally a federation, and this is a very controversial thing for me to say, I've found in policy circles, because there is a very effective propaganda campaign that South Africa is a unitary state, but we are per definition not a unitary state. But we certainly are a centralized federation. But because we are in fact a federation, the Free Market Foundation believes that the federal features of the Constitution must be accentuated and embraced by legislation, rather than, as currently the case, resisted. And in this respect, we have therefore recommended that Parliament adopt either a single or multiple devolution acts that take those specific responsibilities that the Constitution has entrusted to the central government in Pretoria and bestow those responsibilities upon provinces and municipalities. And of course, the Constitution does allow this kind of devolution. Furthermore, and I think most crucially when it comes to political parties that also favor federalization, this has been certainly the cause of their hesitance. So we recommend that Parliament adopt legislation that assigns more funds from the central government to the provincial and local spheres. Currently, the central government absorbs most of the revenue raised by the revenue service, with comparatively little flowing downward. And we believe that this very inverted pyramid must be righted, with municipalities and provinces requiring an entitlement in law to the greater proportion of revenue raised within their specific jurisdictions. And this will be good because it will encourage municipal and provincial jurisdictions to compete with one another, to attract high value tax paying businesses and individuals to base themselves in those jurisdictions, which would entitle the provincial and municipal governments to more money. So they would have an incentive to make themselves attractive investment environments, attractive residential environments, and that flows into everything. That will mean they'll need to address crime, they'll need to have low taxes, they'll need to have policy certainty, and all these things. If these jurisdictions are entitled to the greater proportion of money raised within their jurisdiction, will incentivize them to do better. But that's not currently the case in South Africa, and we believe that that's an issue that Parliament must address with legislation. The Free Market Foundation has also recommended that Parliament adopt legislation that creates intergovernmental processes and procedures, including for the courts, that better respect the federal design of the Constitution. And just one example of this is that we've had the central government and provincial governments really abusing the power of intervention, of constitutional intervention that those governments have to intervene in the affairs of a provincial government or in the affairs of a municipal government. And that's been exploited for partisan reasons. When one party governs this area, they will want to intervene in a jurisdiction that is governed by an opposition party and cause chaos. So we would recommend that legislation be introduced that severely limits that and assigns very, very high punishments to politicians that wield the constitutional power of intervention in a partisan way. Finally, under this category of federalization, we have recommended that Parliament adopt self-determination legislation under Section 235 of the Constitution, which should grant any self-defined linguistic and/or cultural community in South Africa significant authority over state services within those communities. This legislation should entitle communities to govern themselves, especially in matters of education, welfare, healthcare, and safety, and to provide municipal services to their tax-paying members. Crucially, and this is really important, these units must be self-funded, but must at the same time be entitled to substantial tax and rate relief and exemptions. Ladies and gentlemen, I now turn to the category of the rule of law, which Mornay already gave us a very good and thoughtful introduction to. It's such a crucial topic now in South Africa, especially in light of the recent Spaza shop crackdown. And I want to spend a minute on this issue before I get to the FMF's discrete proposals. So the crackdown, in our view, holds a severe danger to the rule of law that we don't think people often realize. So just a little background, the Department of Cooperative Governance and Traditional Affairs has published what it calls a standard township economies bylaw that municipalities around the country are now expected to adopt. The reality is, and this reality might make a lot of people uncomfortable, is that everything in this bylaw, virtually everything, is already law in some form or another. So what are we talking about here? We're talking about informal, often unregistered shops that do not even begin to have the resources necessary to hire compliance officers or to hire lawyers. They are already not complying with the diktat of regulators. So why do we think that making another law will change that? Now, please do not interpret what I am saying as we need better enforcement rather than more law. I think that being too zealous in enforcing economic regulations like these could be very destructive. So that is not what I'm saying. Already the choice for informal entrepreneurs is to either remain informal and unregistered or to go out of business. That is the choice. And stricter enforcement will push them down the road of going out of business more, which is absolutely tragic and unacceptable, really, in a low growth, high unemployment economy such as that of South Africa. So, what is the answer? The answer, of course, is to deregulate and to liberalize, as Mornay shared in his briefing 2 weeks ago in our paper on regulation. By reducing the compliance burden, we make it easier. In fact, we incentivize informal businesses to register and operate within the bounds of the law. But if operating within the bounds of the law is so burdensome that these entrepreneurs simply cannot do it, then we are being very mischievous with our legislative and regulatory pens. This new bylaw reproduces legal content that already exists, and that means we are over legislating. And not only that, we are over legislating something that we know. Ladies and gentlemen, we know. This is not speculation. We know it will not be complied with. And this is not good for the rule of law. So now I turn to our recommendations on how the rule of law can, in fact, be strengthened in South Africa. The Free Market Foundation firstly believes that the courts have been too deferential in upholding the rule of law. When I say this, I do not mean that the courts have not addressed corruption, because somehow in our national discourse, we have confused criminality within the state with observance with the rule of law. So what is the rule of law? It is a set of, in my view, pretty much universally agreed upon principles about the making, content, and application of the law. And in this respect, South Africa's courts have been very reluctant to tell Parliament or the executive when they step out of line. We therefore recommend that Parliament should adopt legislation that not simply empowers, but directs the courts to uphold the defined principles of the rule of law when they come across breaches in legislation or in regulations. This would include, to name one example, but this is probably the most important example, directing the courts to invalidate any legislation that gives regulators or ministers or any other official or body an unrestrained discretionary power. Now, our law is replete with discretionary powers that government officials can wield without limitation. And this must be brought to an end by the courts, because this is simply in conflict with the rule of law. There cannot be legal certainty if you have to wonder whether the regulator is going to revoke your license to do business simply because the regulator got up this morning and thinks you're no longer acting in the public interest. That is an unrestrained discretionary power when regulators are told to act in the public interest. Discretionary powers must be very strictly circumscribed. They must be subjected to very clear legal limitations about how they may be exercised. And we haven't gone nearly far enough in this respect. The Free Market Foundation is also recommending that legislation be adopted that makes it legally compulsory for any new legislation or regulations or policies to be subjected to neutral and high-quality impact assessments. Currently, it is only a matter of cabinet policy that such assessments must be conducted. But this policy is flouted more often than it is adhered to. And with very few exceptions, at least in my experience, every impact assessment reads like a marketing pamphlet written by the author of the regulation that is supposed to be under scrutiny. We cannot have departments or sponsors of legislation or regulations or policies drafting their own impact assessments. There have to be neutral and independent third parties that do these things, and they must do so according to a set framework that I think in particular mandates looking into budgets and costs, amongst other things. But if you read the majority of so-called impact assessments that our government produces, you will see basically nothing on cost. It is just assumed that there is a big pot of money somewhere that will fund anything that the government wants to do. And that is simply not true. And that is a very dangerous idea. And an impact assessment in particular must exist to account for that. And I think the national health insurance is a great example of not only do the impact assessments not address costs, but the minister also very kind of brazenly says that he actually doesn't care about costs or anything like anything silly like that. And I mean, you can't talk about rule of law in South Africa if you have government officials acting like that or policies being adopted on such a very shaky basis. So in respect of regulation, we are also recommending that legislation be adopted to more strictly define and limit what regulation means in South Africa. Currently, virtually every body of government is allowed to adopt binding regulations under such euphemistic names as notices, directives, or most absurdly of all, even guidelines. So Parliament should in this legislation state precisely which institutions by name may adopt binding regulations, and this must be a relatively fixed list and a relatively small list of institutions. And outside of those few institutions, only non-binding guidelines, and when I say guidelines, I mean guidelines, it's a recommendation, may be adopted rather than binding regulations. The law must also limit how long regulations may be. I think many of us in the policy world, certainly many of you in the media, have come across regulations that go into hundreds of pages of legal substance. And this is unacceptable in a ostensibly perhaps a democratic state where only elected representatives may adopt substantive law. Regulations must be technical, to the point, and concern themselves only with formalities. Substance has to be left to Parliament. Regulation may not be used as an alternative to legislation. Finally, ladies and gentlemen, under the banner of the rule of law, the Free Market Foundation recommends very practically, I would say, that the threshold for court applications that must occur in the High Court be raised from the current amount of 400,000 Rand to some higher amount. This will allow South Africans much greater access to the magistrates' courts, which are usually cheaper to litigate in. And furthermore, the maximum monetary jurisdiction of the small claims court must also be raised from the measly 20,000 Rand, where it is currently set at, to, we recommend, about 100,000 Rand, which will also significantly broaden access to the courts for poorer households that have disputes. This brings us to the category of private property, ladies and gentlemen, which is guaranteed by Section 25 of the Constitution and still guaranteed by Section 25 of the Constitution, despite popular opinion to the contrary. We recommend that Parliament immediately abandon any legislative schemes it has undertaken to weaken this fundamental right. By this, we have specifically the expropriation bill in mind, and certainly any future attempts to amend the Constitution to undermine property rights of all South Africans. And in this respect, we focus specifically on the notion of confiscation, so-called expropriation without compensation. So real expropriation law, as it is known in every free society around the world, knows no concept of compensationless takings. Expropriation, the very legal doctrine itself, includes the payment of compensation for very good and very logical reasons. The wordplay that politicians and academics and the media and activists, of course, have engaged in to try and pretend that there is such a thing as expropriation without compensation, or the far more nefarious idea of nil compensation, the idea that you are being compensated but to the amount of 0 rands, completely bafflingly ridiculous. That should be put to a complete end and should never resurface in our so-called open and democratic society. There are very good reasons, ladies and gentlemen, why every country where property has been seized by the state without paying market plus compensation has become a poor dump. Investment and development will dry up if Parliament continues to play this game. And really, if the GNU is to achieve anything, it must be to put expropriation without compensation to bed finally. And also in this respect, we propose that Parliament adopt new land reform legislation that rejects the paradigm of redistribution in favor of a renewed emphasis on the principle of restitution. Redistribution is a political, not a legal concept, and is premised on the kind of central planning according to neat little formulas that has no place in a free society. This kind of central planning should have ended with the Cold War in 1989. Restitution, on the other hand, is a very old jurisprudential concept that is very well rooted not only in Western legal systems, but also in indigenous African legal systems. Where someone can prove that a definable piece of property belongs to them in particular, they must, of course, receive that property back or take some other form of compensation if they choose. This is a matter of justice, not petty politicking, and dishing out random plots of property to random friends of the state, as one sees under the current paradigm of redistribution. We have also recommended that the new Land Court Act be amended to strengthen due process and adherence to the rules of evidence. When this act was adopted about 2 years ago, it watered down the ordinary legal standards that are still applicable in the High Court for the Land Court. And we deem this to be a completely unacceptable state of affairs for a superior court of law. And finally, in the matter of private property, the Free Market Foundation has recommended that the National Water Act and the Mineral and Petroleum Resources Development Act should ideally be repealed in their entirety to signal that South Africa is actually serious about reform. Both of these laws effectively nationalized the private property of owners across the country and vested South Africa's vast water and mineral and petroleum resources in the ownership of the state, by no matter what euphemistic terms are used as proxies for ownership. The South African state is a bad owner, ladies and gentlemen, and I don't think I need to explain this because it has been proven to us over and over and over again. Placing our most vital resources under its ownership is a dangerous decision, and it must be righted before too long. South Africa's once prosperous mining industry has already been harmed by the MPRDA, and I think we are at an important juncture to try and avoid a water crisis by undoing the National Water Act. Ladies and gentlemen, the final category of reforms that the FMF is putting to government as part of our Liberty First initiative is in the area of civil liberty. So earlier this year, before the election, the FMF launched its Section 12 initiative, which looked specifically at freedom under law and how over-criminalization and out-of-control violent crime threaten this very freedom. And we are putting these proposals from the Section 12 initiative to the government once more. I will not cover all of these in detail because it is quite substantive, but I will only say that South Africa requires a large degree of additional certainty in criminal law. Because most ordinary peaceful conduct, not most, but much ordinary peaceful conduct is criminalized in South Africa under legislation and regulations that ordinary normal people like us do not even know exists. And in this respect, I've said it before and I'll say it again. Myself and everyone watching this video right now or in the future has committed crimes. We are all criminals because there are things that we do not think is particularly contentious, but which I can guarantee you, and I am willing to enter into a wager with you, is criminal under some or other piece of legislation or regulation somewhere out there in South Africa. And this is very problematic, again, for the rule of law, but certainly for the freedom of ordinary individuals. So in this respect, the FMF has proposed the adoption of a single comprehensive criminal code. Secondly, South Africa requires a very large degree of decriminalization to ensure that our criminal justice institutions to the extent that these might still exist, do not have their attention unnecessarily distracted by victimless crimes. This allows them to focus on real violent crime that has tangible victims and has caused tangible harm to recognized legal interests. And in this respect, we have identified the Hate Speech Act as a very recent significant law that should be repealed, not only to safeguard civil liberty, but to ensure that our police and our prosecutors and our prison capacity are not wasted on going after people who are offensive, as opposed to people who actually engage in violence. And some people might say, well, you can do both. My apologies, but I think our police and our prosecutors and our courts and our penal system have shown that they cannot do both. So we do need to choose. We do have to focus our resources. We've also called for widespread decentralization of policing, which dovetails neatly with our first recommendations regarding federalization. In our view, the other spheres of government, being municipalities and provinces, must play a far bigger role in combating crime than they currently do. But even more than that, communities and commercial enterprises must also be allowed and empowered, truly, to take tangible steps towards securing South Africa from predation. Ladies and gentlemen, I know this has been a mouthful, but I hope it goes to show that there is still much that can be practically and in a constitutionally validly way be done to improve South Africa's legal system and respect for people's property. Through these reforms, all of us, including and really especially the poor, I remind you of that huge difference between how well the poorest of the poor do in economically and socially and civically free countries, and how very the despair and misery that the poor experience in those countries where governments play a far bigger role in society and the economy. There is a huge difference, and the poor fare much better in free societies. So through these reforms that I've alluded to now, and those that we've outlined in our other briefings, finally, South Africans will be able to reap the benefits of economic freedom. So I thank you, and I am very eager to take your questions if there are any.
Thank you very much, Martin. Yes, indeed, very dense, a lot of information, but you explained it quite well. And I think it certainly gives a lot of people a lot of food for thought. As Martin just mentioned, we do have the opportunity to for the viewers to ask questions. That could be viewers, whether you're from the public or whether you're from the media. Do feel free to, on whichever social media platform you're watching this stream from, just ask your question in the comment, and we'd be more than happy to answer those questions. But Martin, I'm just going to take some of the moderator's privilege here and to use the opportunity to ask the first question. And I think this is a question that I've actually get quite often when we do talk about federalization and about decentralization. And well, I won't state it the way I've heard it before, but it basically comes down to people see how poorly their local governments perform certain actions, and people see there's lack of service delivery, and often that lack of service delivery, it's not the case that national government isn't coming through, it's the case that local government isn't coming through. So how does one address that particular issue when it comes to decentralization and when it comes to federalization? Is there some mechanism to ensure that it's not just the authority and the power that's being devolved more locally, but also some form of accountability? That's basically my question.
Yeah, so that is a question that comes up very often, and I think the issue there is that we have a large degree of maybe call it status quo bias, where people think that, well, under our current system, our municipality, and I've had DA people kind of also say this. It's like, yes, we support federalism, but some municipalities in Limpopo or the Northwest, surely they cannot be empowered to do more, because look at how they're failing, look at how hopelessly corrupt they are. And that's status quo bias, because they're taking the current framework within which governance happens in South Africa and assuming that just replicates even if the framework changes, and that is not the case. So you've alluded to accountability, and that is what it comes down to. So currently, failing municipalities are plugged in to the national tax-paying base. So a completely failing municipality somewhere in Limpopo knows, and I mean the political elite there knows, that regardless of how much they fail, they will simply be able to go cap in hand to the central government and say, "Oh my goodness, we have now made a big oopsie here, and we need money to solve the problem." And the central government, they can say no for a while, but ultimately it comes down to the legislative paradigm that kind of encourages what they call cross subsidization. So the money will eventually come because the central government will feel obliged to help, even though it's actually just enabling further bad behavior. What we're proposing is that authority and consequences be firmly vested where the mistakes are made and where the bad decisions are made. So when a municipality does fail, and of course they are failing, and I'm sure that even if there is a large degree of federalization, many of them will continue to fail. The consequences of that failure will vest where the failure occurs. That means that well-performing municipalities in areas where the community is active, where the community actually thinks through how it votes, in areas where communities are involved in community policing forums, are ensuring that corruption is addressed before it gets too out of hand, those municipalities will do well. But where you have municipalities where people do not think through how they vote and where people are not involved in how politics plays out around them, those will fail, and rightly so. Ultimately, rightly so, they will fail. And that's not a death sentence, because at any point, can they decide, listen, okay, we're tired of failing. In the next election, we're going to vote better, and from now on, we're going to establish an oversight committee of local citizens that has a look at how money is spent. And then the problem solves itself. Then the authority that that municipality has can be wielded for the benefit of the community. That is currently impossible, because no matter how well you or I vote, it does not matter for other municipalities, and we ultimately have to bear the consequences of corruption in municipalities where we have absolutely no say and no skin in the game. So certainly you're right. It's a very common criticism. It's a very common criticism from even well-thought people, but they have to abandon the status quo bias. We are very much asking for the framework to change, and it is a legislative framework. It's not a constitutional framework. We are very much asking for the framework to change and for consequences to vest where they must, rather than being generalized to our whole society, which just it destroys accountability.
Yes, I think that's an important point, Martin. And in fact, especially that point that you made regarding the fact that it's not a death sentence. And people we all agree that competition makes everyone better. If it's in the private sector, everybody says, competition is fantastic. It forces everyone to be better. And that's why we also have certain commissions, which maybe not always as effectively, but we have an entire competition commission, which which establishes the fact that competition is good. We want more competition, but there seems to be an extreme reluctance to allow competition when it's within the state, and that can be when we're talking about Eskom or Transnet or any of those state-owned enterprises, but also when we're talking about municipalities. There's this reluctance to actually have municipalities compete, to actually have a legislative structure, legislative framework that incentivizes good behavior, that says, if your municipality is performing well, that could lead to more money in your coffer, and punishes bad behavior. So I think not only is it not a death sentence, it could actually halt some of the decline in the poor performing municipalities, and it could actually ramp up the prosperity in the good performing municipalities. Yeah, well, that's my question. We also have quite a few questions in the comments. We have one from YouTube, which is, can you talk a little bit more about impact assessments and how they would ensure better law and prevent the introduction of laws the cost of which we simply cannot afford to carry? So what is that link between the impact assessments on the one hand and the positive outcomes on the other hand?
Yeah, so I mean, one of the issues with kind of policy making in South Africa is, as I alluded to earlier, a complete a complete lack of thinking about long term. So Frederick Bastiat and Henry Hazlitt both kind of pointed out the same principle, in that, listen, if you want to get economics right, you have to have a long term view, and you must also be aware of unseen costs. Now, in South Africa, not only is our government and our policymakers, and let me just emphasize, I'm not just talking about the ANC. Like, this is a political cultural issue in this country that transcends every single political party, every single one, not one exception. They do not think about costs at all. The idea is you have to have good intentions, and you have to have a well-crafted, the more well-meaning parties who would want to write a very nice policy using very kind of precise language, and then that goes, and now we implement that. Questions of cost are very rarely, if ever, thought about, and when they are, it is only kind of direct costs. That is completely insufficient. Now, if we were to actually do the impact assessment thing right, and again, crucially, people who understand economics, who are not just cheerleaders for the government's agenda, can then say, well, wait a minute, NHI alone, this one policy, national health insurance, that alone will need to lead to at least the doubling of the entire National Department of Health's budget, like a times two, a doubling of the budget. If you don't have people pointing that out, then you just have ministers saying, well, we'll worry about the cost later. But if impact assessments become binding, if their conduct is binding and independent and must be of a high quality, then it'll be very difficult for a minister to say, well, we're implementing NHI, and here's our impact assessment, which says, well, we can't afford it, and we won't be able to afford it for decades while we're not growing our economy. That'll be very difficult to happen. So that will be a break on a reckless policy and reckless lawmaking, because there will be a cost attached to what is being done, and it might drag our political discourse away from this very simplistic idea that we just have to have politicians who are well-meaning and they adopt the policy, and then by some force of magic, kind of what the policy says in text becomes our reality in practice. That is not how it works, and I don't think impact assessments are the be-all and end-all that solves that problem, but it is at least a visual data point that we can rely on in the future to say, listen, actually, we can't get to this advanced level of the conversation until the cost issue is solved. I mean, NHI is one example. The other one is something that it reappears in our discourse every 5 or so years, this idea that the government must provide free internet data to everyone. I was on a panel discussion about that about 2 years ago with My Broadband, a bunch of very smart people, but ultimately no one was interested in costs except me. And then you just see this as a transcendent issue across all policy. No one cares about costs. And certainly another thing that impact assessments would look into is, like with this PASA crackdown, is to say, listen, these shops have not complied with these laws. Why? The impact of this policy will be zero, if not negative, because this is just another policy that will not be complied with. So these impact assessments really transcend a lot of issues that we have in policy making, and really allows the public to kind of get a better insight into whether our policymakers are being reckless or whether they're truly being considerate. So I think it's a very important institution for advancing economic freedom.
Yes, I think most people may not know this, but we as a think tank, we tend to look quite a bit at these impact assessments, and they're so crucial because they just give you some basis upon which you can evaluate a policy. And when they're doing poorly, when they're done poorly, when they seem to be more like a wish list or a best case scenario that the legislature is hoping for, then it's almost useless in that case. So it just gives us no real information, and it also shows on the part of the people developing those regulations or those laws that they don't feel it necessary, or at worst they don't feel it necessary, or at best maybe they just didn't consider. I'm not sure which is worse or best there, but that's something which they took into consideration, and that really is another part of the rule of law. It's not just the way that it applies between citizens, but also the fact that a fundamental principle of the rule of law is the fact that state actors are also subject to the law. They also have to obey the law, and if a policy is too vague, then that's unconstitutional. That's grounds for striking it. At the first instance, you don't have to look further at it. If it's too vague, you can't implement it. But there's actually another question, and you sort of alluded to it there in your answer, and that is the question of spaza shops. And I think this will be the last one before we sign off. Is just this question of spaza shops. It's been in the news quite a bit recently, and I wonder whether you can maybe delve just a little bit more deeply into what is it that the government has done previously, what is it that they're proposing to do now, and why is it that there's what do they believe is the sort of the link between, or the nexus between, the policy and their goals, and to what extent do you think it's either not going to accomplish that, or it may even be harmful in achieving those goals? So that's quite a mouthful. You can just pick up whatever you want there, but the broad question is just on this issue of spaza shops. It has been in the news, and we know that there has been quite a bit of harm, really serious harm. And how does government address that within our Liberty First framework?
Yeah, so I do have a lot of thoughts about this. I'll try to be as brief as I possibly can. So one of the key underlying issues here is that I think South Africa, certainly other parts of Africa as well, but I think South Africa in particular, operates on what might be considered a incorrect assumption that we are a normal Western economy. Now, I think we are, to a very large degree, a Western society and a Western economy, but we are not Norway, we are not France, we are not Latvia. Yet, when you look at our municipalities, if you look at our legal system, our building codes, our health and safety regulations, it is as if there is absolutely no difference between South Africa and Latvia and Norway and France. All of these things are completely standardized without any allowance for the fact that South Africa is by and large a poor society, a very, very poor society, where people do not have, as I said earlier, do not have the money to even look in the direction of a lawyer or look in the direction of a compliance officer to help them comply with the reams upon reams of regulations and bylaws and national acts as well, provincial acts, that tell them to, when you look at them in isolation, it's like, well, yeah, the freezer must be separated by a few feet from another appliance. That alone looks very kind of commonsensical, but that's not the reality in South Africa's informal settlements, certainly not, and not in our townships, in our formalized townships. To some degree, there simply isn't enough space, there isn't enough room. And again, people don't have the money to comply with these regulations. So that's the first issue. We adopt what I'm saying. These regulations are common sense. They seem on their face very reasonable. A lot of it, not all of it, very reasonable. But we cannot apply the logic of Norway, of France, and of Latvia to South Africa, because they do not have the same social and economic circumstances that South Africa operates under. We have to make a very significant allowance for more informal businesses and businesses that don't quite comply entirely with these regulations. And when you look at the rest of Africa, it's even poorer to a large degree. And there, people eat bushmeat. There, people eat in open air markets where food is being made right next to someone selling poison, for instance. And you do not have children dying in droves. Not necessarily. I'm sure there are risks, but this is something that happens, and it must happen like that because Europe was allowed to go through this period in its own history. Europe was allowed to do that, to work its way through informality, one can say, and build upon that and build formality upon foundations of private property and legal due process. It was allowed to do that. Much of Africa is being informally allowed to do that. South Africa is not being allowed to do that because of the very Western, very luxurious regulatory dispensation that we have applied in this country across the board for centuries, really now, I think for at least a century. So that is a problem. That is a very big underlying problem that is not going to help the current situation, which I think the other issue to note here is that what has happened is tragic, and the obvious solution, which I would hope most sensible people agree, is to follow a criminal law process to investigate what happened, why have dozens of children died, what exactly happened, to ascertain the facts. And then when it's discovered, I think inevitably, that someone either acted intentionally, perhaps to eliminate their competition, to poison their product, whatever, or accidentally, but certainly through criminal negligence, to allow poisons to leak somehow into foodstuffs, then there must be criminal law steps taken against those individuals and they must be imprisoned. And that serves then as an example to other businesses in townships to listen, you have to be careful. You have to adapt to your circumstances, but you must be careful because you're dealing with people's lives here. So it's a criminal law solution, but that I hope is obvious to people. But the other thing is that it is so clear that this is being used as a pretext to target foreign nationals. Now, I don't want to go too deeply into this because this is part of a very global issue, but I think South Africans need to be very careful about incorporating Western culture wars into our own policy and political discourse. It's no surprise that since anti-immigration sentiment have become more popular in the West, it has become far more popular in South Africa. These things are interweaving with one another, and we need to be very careful about that. We need to remember that unlike the West, where borders have some basis, African borders are very arbitrary. And I'm not saying let's abolish the borders. I'm not saying that. Don't quote me out of context. But we need to be a little bit more circumspect when we make blanket statements that these people do not belong here, these people do not get to open shops in our cities and in our towns, that our is doing a lot of heavy lifting. It is only by luck or coincidence that somehow Johannesburg is ours, but Harare is not ours somehow. These things we all need to bear in mind and just be careful about incorporating Western immigration culture wars into South African policy discourse, because that is my submission is that is what is happening. A lot of children have passed away, and the government and many government adjacent institutions have seen this as a perfect pretext to adopt this bylaw, which in large part focuses on excluding foreign nationals out of South Africa's township economies and effectively engaging in economic gatekeeping in favor of natives, locals, South Africans, what have you. That is not healthy. We need economic growth in this country without conditions. We do not need more expensive products in this country, which is what the result will be of excluding immigrant populations, which are around the world, have been proven to offer services at higher quality, often at cheaper cost than locals do. Just by the nature of immigration, you are entering a new society, you want to do well, you want to root yourself there. So this is going to make things more expensive. This is going to stifle growth in township economies. It's certainly not going to stimulate growth in for locals and so on, because that's just not how economic freedom comes about. You have to deregulate, you have to liberalize if you want growth. You can't regulate yourself into growth. No one has ever done that, and South Africa certainly will not be the first. So my kind of final thought on this is, listen, this is a criminal law matter. We're not saying that we just have to ignore that children are dying. There has to be an investigation. The culprit has to be identified, and they need to be brought before our criminal justice institutions. But again, we have to deregulate and liberalize if we want to encourage compliance of law, because currently, again, we're imposing a very Western, very luxurious conception of how the world works, especially as far as regulation goes, upon an extremely poor informal context where it simply does not apply. And that's something we have to always bear in mind when we engage in these discourses.
Yes, thank you very much, Martin. I think that was incredibly well said. And I think people don't always realize, obviously, everybody knows how atrocious our unemployment figures are in South Africa, and the extent to which we've not really had economic growth for really over a decade in South Africa. But I think there's this sort of perception that, I often hear about this vibrant informal economy in South Africa. But when you actually look at the figures, we're trailing the rest of the world there. We actually have a relatively small informal sector in South Africa when compared to other countries. If you look at the amount of employment being created by smaller businesses, it's a far smaller percentage in South Africa than it is when compared to the global average. But Martin, we have actually surpassed the hour mark, so I do feel we need to sign off now. If anybody has any questions, feel free to leave those in the chat, or again, if you'd like to watch any of our previous papers, the briefings for any of our previous papers, those are on trade, regulation, on size of government. Those are available on YouTube or Facebook or whichever social media platform you're using. Or if you'd like to read the full paper, either Martin's or any of the preceding ones, those are available on our website at libertyfirst.co.za. Martin, thank you very much. And just a reminder to everybody that we do also have another paper before I sign off. Just a reminder, there's the final paper for the Liberty First series will be next week, and then I have the honor of presenting with the CEO of the Free Market Foundation, David Ansara, and we'll be discussing the topic of sound money, and in particular also looking at the certain suggestions and proposals for cryptocurrencies in South Africa. So if that's something that interests you, make sure to attend next week's briefing. It's going to be at 11, and it's going to be on the Tuesday next week. Once again, Martin, thank you very much. And to our viewers, thank you for watching. Thank you for following. And everybody, please remember to stay free.